She admitted to violating probation, and suddenly Judge Stephanie Boyd gave her two terrifying options: intensive drug treatment or 4 years in prison. What happened next turned this courtroom completely silent.
So it's completely up to you. CR 9686B, State of Texas versus Betty Jean Gonzalez, aka Betty Jean Gonzalez, one with a Z, one with an S. All right, could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Jump as for defense.
And are you Ms. Gonzalez?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Okay. Are you saying Betty Jean Gonzalez, who was placed on deferred adjudication in 2022 CR 9686B for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on February 2nd, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, ma'am. Violated condition number 1 on or about the 6th day of May, 2023 in Bexar County, Texas. The defendant, Betty Jean Gonzalez, aka Betty Jean Gonzalez, committed the offense of possession controlled substance penalty group 1 in violation of condition number 1. And actually, Judge, if I could make an oral amendment to this doesn't allege the amount, but it should be possession.
Oh, you don't need to
okay.
put the amount in, counsel.
Okay. Sorry, Judge.
Oh, no problem.
And we waive the other violations.
All right, to violation of condition number 1, how do you plead, true or not true?
True.
And with regards to the state's waivers, defense, do you have any objection?
No objections, Judge.
All right, did you understand by pleading the violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. I've spoken to defense counsel and Deshaun with probation, and we'd like to refer the defendant to felony drug court, Judge. And if she's not accepted in the felony drug court, we'd like her to go to inpatient, either SATIF or SAFE, Judge.
All right, defense, is that the agreement?
It is, Judge.
All right, Ms. Gonzalez, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Would you state your name for the record?
Betty Jean Gonzalez.
All right. So, Ms. Gonzalez, you know yourself better than I do, better than your attorney does, and better than probation does. If you want the treatment and you have a drug problem, I will most definitely refer you. I'll deny the motion, refer you to felony drug court. If felony drug court doesn't accept you, then you will be accepted into an inpatient treatment facility. But you know whether you can do this or not. Now, with the amount of drugs you had, even though it was reduced to possession, felony drug court may not accept you. And that's based upon the amount of drugs you have. Do you understand?
Yes, ma'am.
Now, so I can do that, or if you would like, I can revoke you and I will sentence you to 4 years in the prison. So it's completely up to you. When people want help, I want to give them help. I want people to do better. I note that you have people in your life, probably young people in your life, because I ordered parenting classes for you. But if you're not ready to take the help and ready to really work hard, because you're going to have to work really hard to maintain your sobriety, to not pick up any more cases. And I know with the possession less than, with a possession penalty group 1, I know the only difference between that case that you have and not having it is the fact that you didn't get a chance to use it. So I understand that. So what would you like to do? If you would like to discuss it with your attorney, you can, but you know yourself better than I do and he does.
I do need the help.
All
I
right.
really do want the help.
So you want the help?
Yes, ma'am.
All right. So I'm going to give you the help, but you're going to have to make better decisions. When things happen in your life, the go-to can't be, I'm going to go out and get drugs, because otherwise what's going to end up happening is you're going to have another case and you're going to be back before me. You understand?
Yes, ma'am.
All right. The court will deny the motion, alter and amend conditions to do a referral to felony drug court. If not accepted, then inpatient treatment, either at, if probation, if you're recommending SATA for safety, all right, that'll be SATA. And if SATA doesn't accept her, then it will be ISF, cognitive and substantive track. And this is to happen while in custody. If you are accepted in felony drug court will be the person that is over your probation. The only time you'll come back to me is if you are unsuccessful, or if you're coming back to me asking me to appear at your graduation.
Yes,
And
ma'am.
I always, if I'm in town, I will be at your graduation, okay?
Yes, ma'am.
All right. Thank you. And state is dismissing the other charge. There you go. All right. Is there anything else?
Nothing from the defense, Judge.
Probation, is there anything else she needs? All right. Thank you. Good luck. Court is calling 2020 CR 4185, State of Texas versus Daniel Antonio Swingell. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Jim Oltersdorf for Mr. Swindell.
Are you Mr. Swingell?
Yes, ma'am.
Is that how you pronounce your last name? Swingle. Okay. All right, Mr. Swingle, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you have a chance to review those documents with your attorney, and did you understand them?
Yes, ma'am.
Are you the same Daniel Anthony Swingle,
Yes, ma'am.
who was placed on deferred adjudication in 2020 CR 4185 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on June 5th, 2020 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Daniel Antonio Swingill, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, December 2021, January, February, March, April, May, June, July, August, September, October, November, and December 2022, and January, February, March, April, May 2023 in violation of condition number 5.
All right, how do you plead to that? Guilty?
Guilty.
I'm sorry.
The courtroom falls silent as Judge Stephanie Boyd calls the case of Betty Jean Gonzalez. Gonzalez was already on a massive 10-year deferred adjudication sentence for possession of a controlled substance, but only months later, prosecutors claim she committed the exact same offense again. The state accuses her of violating the most basic rule of probation: don't pick up another criminal charge. When Judge Boyd asks how she pleads to the violation, Gonzalez quietly responds, "True." That one word changes everything. Judge Boyd immediately warns her of the consequences. By admitting the violation, Gonzalez is now facing up to 20 years in prison and a $10,000 fine. The tension inside the courtroom becomes unbearable. But instead of instantly revoking probation, the prosecution and defense propose an alternative: felony drug court. That's when Judge Boyd takes complete control of the courtroom. She explains that felony drug court is not an easy escape. It's a strict rehabilitation program with constant supervision, treatment requirements, and zero tolerance for failure. Then comes the moment that changes the entire hearing. Judge Boyd looks directly at Gonzalez and says, "With the amount of drugs you had, felony drug court may not even accept you." And then she delivers the ultimatum: "I can revoke you and sentence you to 4 years in prison. So it's completely up to you." The courtroom freezes. Judge Boyd makes it clear this is her final opportunity for help, but only if Gonzalez is truly serious about changing her life. She tells her, when things happen in your life, the go-to can't be drugs. For a moment, Gonzalez becomes emotional and admits the truth. I do need the help. That answer shifts the direction of the case. Instead of sending her directly to prison, Judge Boyd gives her one final chance. The court denies the motion to revoke probation and orders Gonzalez into felony drug court. If she's rejected, she'll be sent directly into inpatient treatment while still in custody. But Judge Boyd makes one thing absolutely clear. This is not freedom. This is a narrow path to redemption hanging over the threat of years behind bars. One failed test, one missed appointment, one bad decision, and prison becomes reality. In Judge Stephanie Boyd's courtroom, mercy exists, but only for defendants willing to fight for it.
Okay. All right, the court will follow the agreement, sentence you to 2 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. You understand?
Yes, ma'am.
All right, we can go off the record. So were the tattoos painful?
No, I mean, the side of my arm was because I got the scar right here. So, but not really.
Are you going to get
I
any more?
didn't hurt the most.
All right. Oh, and why did you do that?
I don't know.
All right. So you have a felony conviction. I'm sure your attorney has told you now, if you were to pick up any more criminal cases, you would be known as a repeater, which means whatever level felony that is, the punishment range would increase by one level. You understand?
Yes, ma'am.
You say you have 5 children, then you need to do better by them. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you for hearing us.
Thank you.
Thank you.